Okay, folks, let's get started. Welcome to this evening edition of Criminal Law video topics. We're going to be talking about mistake of fact. It's an ancient and maddening problem, but it relates directly to the levels of culpability that we've been talking about. Now, we're talking in particular here about mistakes of fact that can negate a culpability element. That is, they're a way of disproving that the relevant state of mind for a given element of the crime is present. There are other kinds of mistakes of fact that might go to the presence of an affirmative defense, but we'll talk about those. That's a topic for another day. For now, mistakes of fact that negate culpability elements. Now, I'm going to address this topic in a dangerous way, and that is, I'm going to tell a story that makes my spouse look a little silly. Now, any of you who are married know this is really, really a bad idea. But in this case, it is a nice story. I've asked permission. Amy says it's okay, so I'll go ahead with it. So one time Amy's going to a wedding, and she's supposed to arrive very late. She's one of the bridesmaids, and somebody has arranged for her to stay in their apartment, but she's going to get in at 2 a.m., and so they're going to leave the door open and leave it unlocked. And then she's just to come in, go down to the basement. There's a sleeping bag there, and she's to sleep there. And then everybody will wake up in the morning and speak. And so, sure enough, she arrives. Her friend lives in this long row of identical townhouses. You see where this is going. And so she goes down to sleep. She sleeps in her friend's basement. Then she goes out in the next morning to get the dress that she needs for the wedding and go back in and get ready for the day, and it's early, and so she goes out, gets her dress, goes back into the apartment, she thinks, and she's down in the basement and is a little confused. It was dark, I slept, but this doesn't quite look right. And then somebody appears at the top of the steps, and Amy says, "Oh, hello, I'm here for the wedding. I slept in your basement last night." The woman was not amused. It turns out it was the apartment next door. Much hilarity ensues, but ultimately they figure out Amy's in the wrong apartment. She apologizes, backs away, and leaves. So this will be our recurring factual setting for this video topic, and that is, can Amy be prosecuted for some crime like breaking and entering? Now, there is a much more serious and much more common setting where this mistake of fact doctrine comes up, and it arises in rape cases and other sexual assault cases. In these settings, let's say we have a defendant, we'll call him Fred. Let's say Fred has sexual intercourse with a woman. It was not consensual. She did not consent. He, however, claims that she did consent. Maybe he truly believes that she consented. And so the question is, what should we do about his alleged mistake? He was mistaken as to a relevant fact, lack of consent, and how should we deal with that? Now, there are two basic approaches. Really, we might say three, but the slide here says two. There's the Model Penal Code approach that we sometimes call the elemental approach. I'll just call it the easy approach. On the other hand, the common law has a handful of approaches to this problem. One is an easy approach, just like the Model Penal Code. It's an elemental approach, and it applies when you've got specific intent crimes. Then there's what I might call the harder approach, and this is a culpability approach that one uses when you've got general intent crimes. And then finally, there's the hardest approach that we use in very unusual situations based on some English case law where you're looking for the moral wrong of the defendant. Now, I want you to think back to the old terminology of general intent versus specific intent crimes. We've talked about this briefly. It's really not very consistent. Courts use this language to mean different things in different settings, but it could mean that specific intent crimes refer to what we might call under the Model Penal Code purposeful mens rea, and then any crime that has a lesser mens rea than that would be called a general intent crime. Another possibility that you see in the case law sometimes is that a general intent crime is sort of the base, and then if the statute says something along the lines of with intent to do something additional or with intent to produce a certain kind of effect. So, for instance, assault with intent to inflict serious bodily injury. That might be a specific intent crime, while assault standing alone might be a general intent crime. What you really need to do is go to the state and ask, just where's your list? What are the crimes that the courts here have declared to be general intent crimes, and what are the crimes that they've declared for this jurisdiction to be specific intent crimes? Now let's take the easy one first. We'll start with the Model Penal Code. Section 2.041 says that if you've got some kind of ignorance or mistake, ignorance would mean you have a blank mind as to that fact. Mistake would mean you have the wrong fact in mind. But either way, as to a matter of fact or law, we'll talk about mistakes of law later, a mistake of fact will be a defense if the ignorance or mistake negatives the purpose, knowledge, belief, recklessness, or negligence required, as the language suggests here. So basically, if the mistake negates the mens rea that the prosecution has to prove to establish each element of the offense beyond a reasonable doubt, then it's a defense. Put another way, if it's a defense to mens rea, it's a defense to the crime. Pretty straightforward. Now, how would this apply to Amy? Well, here's a set of townhouses along the lines that she entered. They all look alike. Let's suppose that she's being charged with breaking and entering. Let's imagine that this is in a jurisdiction where the statute says that there are 3 elements to breaking and entering. All of the objective elements have a knowing mens rea. But if you've got all of those, knowingly make an opening, knowingly in a building, and you knowingly place your, let's say, body into the building without authority to be there, without a privilege to enter, then you've got breaking and entering. She wasn't allowed to be in there. That could be the objective elements of the offense, right? She has made an opening. She opened the door. That's enough to make an opening. It's in a building. This is a place where people live, and that's one type of building. And then the third element here is that she was not authorized to enter, and yet she entered. So we've got all 3 of the objective elements. But was she knowing as to all 3? She says, I thought I was authorized to enter my friend's apartment here, but all of these places look alike to me. I'm from a different city. That will qualify as a defense. In general, under the Model Penal Code approach to mistakes of fact, the mistake of fact will negate any mens rea that is higher than the mental state connected with the mistake. So if it's a reasonable mistake, that is, if the jury believes, oh yeah, all those townhouses look alike to all of us, and mistake anybody could make, the reasonable person would make that mistake all the time, then you would say there's no negligence, it's a reasonable mistake, and so that mistake can negate any element of the offense that would require showing negligence. There was no negligence here with this mistake. Or recklessness. There was no recklessness, no knowing, no purposeful. Because I posited a breaking and entering statute that requires a knowing entry, that's unauthorized, then a reasonable mistake by Amy would be enough. In fact, even an unreasonable but honest mistake would be enough. An honest mistake but unreasonable would rise to the level of negligence. You could call it a negligent mistake. The jury might conclude, you should have known that that wasn't your friend's apartment. You should have looked around. But we believe you when you say you had no idea and you just were completely surprised and unaware. In that setting, again, if the jury believes it was an honest mistake, even though it was unreasonable, that negligence in the mistake wouldn't be enough to establish the last element of breaking and entering, and so there is no knowing entry unauthorized, and therefore you have no breaking and entering here. Mistake of fact is a defense under the Model Penal Code approach here. Under the common law, there are a handful of different approaches to mistake of fact, but one approach in one corner of this world is still relatively easy, and it's the approach we have with specific intent crimes. So here, an honest mistake can be a defense, at least if you're talking about trying to negate the proof of any element that is at the level of reasonableness or higher, and that in effect is all specific intent crimes because they all tend to have purposeful as their mens rea. Now we move on to the harder version, and this is under the common law where we have general intent crimes. So in this setting, the common law says that if you have a general intent crime, such as breaking and entering, then an honest but unreasonable mistake would be no defense. It's only if you have a reasonable mistake that you can claim it as a defense. So if Amy's charged with breaking and entering, and the jury believes, yeah, that was reasonable, all those townhouses look alike, you had no way of knowing, a reasonable person might have gone in the neighbor's house, then the jury could say, even under a common law approach, that would be a defense to a charge of breaking and entering. But if the jury said, no, you really messed up there, you should have looked around, you could have seen that one of them was yellow and the other was green, these apartments don't all look alike, you should have noticed. In that setting, even though they believe that she was mistaken and that she didn't know that she was going into an apartment unauthorized, she was still blameworthy. It was an unreasonable mistake or negligent mistake, and therefore under the common law for general intent crimes, no defense, not good enough. Now there's one more area of the common law to talk about here, and it's even more difficult than the harder version we just talked about for general intent crimes. And this is a doctrine known as the moral wrong theory. It's based in an old case, Regina versus Prince from 1875. This is a setting where a man entices a girl to go away with him, leave her family's home, leave her father and mother, and run away with him, elope with him. He believes that she is 18. It is against the law to entice a girl who is 16 or less to leave home. But he believes she's 18. It turns out she's actually 14. He says, hey, I'm not guilty of this crime because even though the objective element is there, a 14-year-old came away with me, I thought she was 18. And it turns out the jury agrees that that's what he thought. And the jury also concluded that was a reasonable belief. They said, yeah, given all the circumstances, a reasonable person would have believed that she was 18. Question for the court here is whether you can still convict him if he made a reasonable mistake as to the age of this child. One set of judges call this a strict liability crime, but we're going to focus on Baron Bramwell's opinion. It takes a different theory. And Baron Bramwell's approach here is to say, let's ask what you thought you were doing. And what you thought you were doing was luring an 18-year-old away from her father and mother, and that is maybe not a violation of the criminal law, but it is morally wrong, and everybody knows it. Now, there are obvious questions about how everybody knows this, and maybe it was more obvious in England in 1875 than it would be today. And that's the topic that we talk about with the legality principle. But let's grant Baron Bramwell that point. Everybody knows that it's wrong to lure an 18-year-old away. In that setting, he says, if it's a moral wrong, even though it's not a criminal law wrong, then that's enough for you to forfeit your use of this mistake as a defense, as long as you were culpable in any way, whether it be under the criminal law or just in a more general moral sense. No use of the defense. So notice the Model Penal Code is more of an elemental approach. It's just asking, has this mistake displaced the necessary proof for one particular element? Under the common law approach for general intent crimes, or this more difficult moral wrong theory that's used in only very few places, the approach is more of a culpability approach. Just, were you blameworthy in some way for your mistake? And if you were, then that's all we need to know. It was blameworthy. You're not going to be able to use it as a defense. So in general, I encourage you to think of this area as part of a long-standing tension in the criminal law between more precise elemental analysis that focuses on exactly how much wrongdoing was involved versus more of a yes-no, was there wrongdoing at all here? And if so, it's a crime and we can go forward. More of a culpability approach that uses harm very often as a leading indicator of whether there was culpability. So keep your eyes open for that as we go forward. We're going to be practicing with both the Model Penal Code elemental approach and the common law mixture of approaches when we talk next. See you then.